back to the rear pod. Alright, so today we're going to discuss the Endrew versus Douglas County case. This was a 5th grade student, Endrew, who was attending a school at the Douglas County School District, and he then switched to a private school because he felt that he was not advancing enough in his IEP. So the key issues. So he had several behavioral issues that the school was not really equipped to address, including like climbing on desks, climbing over students, that sort of thing. But the school also did not have a formal plan for these students, which is kind of unbelievable. So there was no plan for Endrew as far as behavior goes. He wasn't making much progress in public school. His IEP barely changed from year to year. His parents took a look at it and noticed that there was only like minute changes, which they should be changing drastically because he should be improving every year, so it should keep moving with him. So frustrated with the school, they decided to enroll him at Firefly Autism School, and they wanted the school district to pay for his tuition because they felt that they had violated FAPE. The appropriate part of FAPE was what they felt was violated because they did not feel that he received an appropriate public education because his standards were set so low. When he attended Firefly Autism School, there was significant progress he made because they set him up with goals that so he could improve, but it had a high price tag at $70,000 a year. So obviously I would hope the school would pay for it. So the main issue that they wanted to address was that the school wouldn't refuse to pay for it, saying that they were not in violation of FAPE and that they did not owe them the money for the school. This court case challenged the Rowley decision, which said that children with IEPs need de minimis improvement, which is basically just the bare minimum. They just need to improve at some amount, but it doesn't need to be significant or anything like that. So this case challenged that because Endrew's parents felt that that was not enough.
So the outcome for this case, it first went to a judicial hearing, which was part of the family's due process rights under IDEA. And at that due process meeting, a hearing found that the school had not violated FAPE because they had met the de minimis requirements in Rowley. And then the parents appealed that to a district court in the state of Colorado. And the district court also decided that the school had not violated FAPE because of the Rowley decision. And then the parents appealed yet again and brought it to the 10th Circuit Court at the federal level. And the 10th Circuit Court also decided to uphold the de minimis precedent from the Rowley case. And when the case was appealed yet again, the parents brought it to the Supreme Court, and the Supreme Court decided that a de minimis standard for an IEP actually did now violate FAPE because expecting children to have the bare minimum of progress is not really an appropriate education for anyone. And the whole concept of IDEA is to provide children with special needs with a worthwhile and meaningful education. And if you're giving them the de minimis progress, then that's not really a worthwhile education at all. So a couple of the most important quotes that came out of that were, "A school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances." So just really saying that the progress that a child makes in their IEP needs to be evaluated on an individual basis. And then every child should have the chance to meet challenging objectives, and that's one of the most important parts to come out of this case.
Right, and so a lot of the educational implications that came out of this was, as you were saying earlier, de minimis was no longer considered to be enough and should not be considered the standard that schools need to strive for, and essentially told schools that they need to significantly up the goals of their students' IEPs and make them, the quote was that IEP goals for children with significant cognitive disabilities they need to meet the needs of a child and show that they have goals that are appropriately ambitious. Even if they don't meet state standards, they need to be appropriately ambitious and challenging and rigorous while still being attainable. So they can't like have standards for them that are on the same level as some of their other peers, but they still need standards that they can strive for and actually be challenged by, rather than just having them sit there learning the absolute bare minimum of what they need. And so this was a really big deal for how IEPs are structured. And so now IEP teams need to implement policies, procedures, and practices relating to and so goals, identifying present levels of academic achievement and functional performance. They need to have the setting of measurable annual goals, including academic and functional goals. And third, how a child's progress toward meeting annual goals will be measured and reported. And so, so that was a lot of like just how the IEPs are structured. And then this was not decided at the court, but actually this past June, the public school that Endrew had been attending before he went to the Firefly School for Autism, the family was actually reimbursed for their tuition, and the reimbursement was a settlement of $1.3 million. So that that was not settled in court, that has set a precedent that will be used in future cases like this, where schools may actually have to pay and provide the free part of a free appropriate public education if they cannot themselves provide it.
Do you know if that $1.3 million like covered, because that seems, I think I remember reading that he was there for about 5 years, and so 5 times 70,000 is not 1.3, so some of the money's got to be just for compensation for the time while he was there.
They may have also had to reimburse the family for the court fees.
Oh, that's true.
I think that's exactly the point, is that like it covered like all of like the tuition they've had to pay over the years, and then like a lot of like just compensation money for all, like you were saying, like all the strife they've been put through, because this case started in the district courts in Colorado in 2012, and then this settlement didn't come around until June 2018. So covered a lot of that, and then like court fees and some of that. So doing the math, like a rough estimate, it actually comes out to covering pretty much all the financial strife this family's been put through over the years.
I mean, I think that it's more than fair.
Absolutely.
Yeah.
They're definitely in violation of FAPE. So the last thing is like, does this support IDEA? I mean, we'll take this a little bit farther, but yes, obviously, because the Endrew case really defines the scope of FAPE and what appropriate is considered, because technically, by the Raleigh case, if the school did provide appropriate education, which is why those lower courts couldn't do anything about it, because they actually had to change the law. And then once it went to the Supreme Court, they were like, that is, like, to me it's horrifying too. I'm glad that they all agreed that, because people with disabilities deserve a great education, they deserve to make improvements, even if they're not the same improvements that their fellow students are making. Like, they deserve to be making the same amount of progress, just in different areas.
Yeah.
Yeah, that was like one of the things that really shocked me the most, was that this wasn't decided until 2017. So for almost 50 years, IDEA had been around with the purpose to help further the education of students with special needs and disabilities, and nobody had actually defined FAPE really in a meaningful way up until almost 50 years later. And so it makes you wonder how many children were just kind of thrown through school with the de minimis standard.
Do not like that
so,
term.
Yeah, I know, it's awful.
It's terrible.
Yeah, I was just absolutely just blown away by the fact that they are not defined as appropriate. And in some of the articles I was reading, that parents were still a little nervous because it's like, I don't know if I have a better way to write appropriate, but it's still left to some subjectivity.
Right.
even after this case. Now, granted, it's more than de minimis, so like hopefully in the lower courts now that can be decided. But technically speaking, it's still pretty ambiguous.
Right, and I think like this was so landmark because it expanded IDEA so much. Like, cause like you guys were saying, like it was just this very like it existed, but it really hadn't been clearly defined, and so a lot of things like FAPE and stuff had kind of gone to obscurity and really not addressed as much as it should have been. And so I think it'll be very interesting to see in the future how many more cases get brought up like this, because hopefully with this decision overturning the 10th District decision back at, before it got to Supreme Court, this kind of thing will not have to go to the Supreme Court and spend years going through this, and it can hopefully end earlier through like the due process situation with IDA, and also and in the lower courts, and so it's a lot easier for students to get the education that they deserve instead of having to spend 6 years, because like he's what, in high school now? Or something? He's a lot
about
higher.
10th grade, I think.
Yeah.
I mean, I was glad that he was in that school that supported him for that whole time, not at the public school, because I just can't imagine how much education. I mean, he already lost his, first 5 years of education to this not, he could have grown a lot more in that time. But I am glad that he was at a school that was supporting him.
Right.
It was also pretty shocking to me. I had read another article that was talking about how at his old school, the public school, they had observed these behaviors that were undesirable, and how they had put a behavior plan into his IEP, but it was never quite finished. They had marked it as a draft every single year, and like it makes you think about how many public schools out there don't necessarily have all the professional development and skills needed to think about behavior for children with disabilities and how to facilitate minimizing these behaviors in a meaningful way. Because draft to me means that nobody ever actually made a definitive plan on what they could do to help. It means that
they were like, oh, maybe we should put something together, and then like it never actually ended up coming about. Yeah.
That's definitely dangerous. I have like a question to pose. So, this has changed the standard for IEPs, and so us as teachers, we're going to need to go back and look at our students' IEPs, and maybe we got to reevaluate and make sure that we haven't been setting those de minimis standards for our students, and make sure that if that's what their current IEP is set to, they need to be revised immediately so that we are not violating FAPE as well.
Well, I think that's going to be a situation where a lot of teachers like us are going to have to deal with the next couple of years, is really reevaluating a lot of these IEPs that students have currently, and also like really just kind of retraining, like you were saying, like with the behavioral thing just being a draft. Like I think a lot of teachers in schools weren't equipped with teachers who knew how to deal with that kind of stuff, and so now with this new decision by the Supreme Court, they're gonna have to do a lot of retraining. So I feel like there's gonna be a lot of like growing pains initially with throwing this in, but like it really will over the years help like really develop this, and it's so necessary, obviously.
Yeah, with what you guys were just saying, since this was only decided in 2017, there are some kids who, because of the annual evaluation, this might be the first time that they have more than a de minimis standard in their IEP.
Blows my mind.
So you have to think about how we're now trying to balance more than de minimis progress with students who have only been getting the bare minimum progress. So going from bare minimum to more than that, how is that going to affect kids who have been skirted by the whole time?
Yeah, it's definitely going to uproot a lot of IEPs. Now my hope is that in several schools that people, parents have fought for it, and schools have agreed that that just because that standard is there as the bare minimum, there's still people that deserve the bare minimum. So I'm hoping that in a lot of schools that it's already just been assumed to be more than that. But I know that especially the schools that don't have the resources, that this might be a serious upheaval. And one question I have leaving this is is there someone checking these? Like, is there someone going through kind of like how Doyle would go through the IEPs and stuff, like double checking and making sure that they are not now in violation of FAPE because they weren't before?
Yeah, because that's a big problem if it's only parent responsibility to be checking their student's IEP, excuse me, and then they need to be aware that this decision was even made.
Yeah.
So that there is more than a de minimis standard now.
Yeah, I think that's definitely something we should look into going forward, is making sure that that is being checked, because, I mean, just from like a school district standpoint, like you're gonna lose a lot of funding that way too. Like if you're just thinking about the money and like step away from the student for a minute and you just think about the money, like that would be a lot of money in court cases that is gonna go away from children's education because schools are going to be in violation of FAPE. So.
Right, and I think there's especially going to be a lot of pressure going forward on schools to do this kind of thing, because there's, especially like once people start, once this becomes more and more common knowledge, it's still a fairly recent case. Like once it becomes more and more common knowledge among parents and people like that, it'll be a lot more on the schools to really like commit to doing this to doing these redrawing the IEPs and the goals.
Well, I just want to say thank you for like meeting today and to discuss this, because this is a major precedent. So it's definitely something that we need to pay close attention to, and especially in the schools that we work in the future.
Yeah, you both brought up a lot of things to think about.
Yep.